changed your mind after filing California's joint petition together? Here is how Form FL-720 works. Who can revoke, the paperwork you file alongside it, how service works, and what happens to your case afterward. What is Form FL-720? Form FL-720 is the California Judicial Council form titled Notice of Revocation of Joint Petition. It exists because of Senate Bill 1427, Chapter 190, Statutes of 2024, the same law that created the joint petition, Form FL-700, effective January 1, 2026. The form itself is short. It identifies you, your case, and states that you are revoking the joint petition you and your spouse filed together. It does not ask you to explain why. The substance of the change happens in the amended petition or response you file alongside it, which is what actually converts the case. Who can revoke and when? Either spouse can revoke, regardless of whether they filed as Petitioner 1 or Petitioner 2 on the original FL-700. Revocation is a unilateral right. You do not need your spouse's agreement, and you do not need a judge to approve it. The only real deadline is this: revocation must happen before the court enters judgment in the case. That single deadline means the window is often wider than people expect. It stays open through the 60-day period for exchanging financial disclosures, any delay in reaching final agreement on every term, the 6-month statutory waiting period for divorce. Once the court has entered judgment, the case is over and there is nothing left to revoke. How to revoke? Step by step. The process follows the same instructions the Judicial Council built into the FL-700 info sheet for the joint petition itself. Decide which amended pleading you need. If you were Petitioner 1 on the original FL-700, you file an amended FL-100 petition, checking the box that marks it as amended. If you were Petitioner 2, you file an amended FL-120 response, also marked amended. Either spouse can be the one to revoke, so this depends on which role you held, not on who wants to revoke. Completing Form FL-720. Fill out FL-720 with your name and case information. If you have an attorney for this case, include their state bar number and firm name. The form states that you are revoking the joint petition filed in this case. File both documents together, same day. File FL-720 and your amended FL-100 or FL-120 on the same day, in the same case, using the case number that was already assigned when you filed the joint petition. You are not opening a new case. Pay any required fee. Checking with your county superior court clerk about whether a fee applies to filing the amended pleading. Filing fees are set and administered county by county, so confirm the current amount before you go in. Serving the other spouse. This is the step that makes revocation different from the joint petition itself. When you originally filed FL-700 together, the petition was deemed served on both of you automatically, the moment it was filed. Revocation does not carry that shortcut. Once you file FL-720 with your amended FL-100 or FL-120, have someone 18 or older who is not a party to the case serve your spouse with the filed paperwork. That server then completes a proof of service, which gets filed with the court, the same way service works in a traditional divorce case. Revoking the joint petition moves your case into the process built for disagreement. What happens to your case after revocation? Revocation does not close your case or make you start over. It converts the same case from the joint process into the standard petitioner and respondent structure. Concretely, once the amended petition or response is filed, Petitioner 1 becomes the petitioner. Petitioner 2 becomes the respondent. Whichever role you held on the original FL-700 carries forward. The case number stays the same. You are still in the file you opened when you filed the joint petition. The original filing date is preserved. For purposes of the 6-month waiting period and other deadlines, the case is treated as though it started on the day the joint petition was filed, not the day of revocation. No new summons is issued. Common reasons couples revoke. The statute does not require a stated reason, but in practice, spouses tend to revoke the joint petition for a handful of predictable reasons. A disagreement surfaces. The joint petition assumes agreement on every term. If a new disagreement about property, support, or custody comes up after filing, the joint structure cannot hold it, and one spouse revokes to move the disputed issue into a process built to resolve it. Someone needs a temporary order. Because neither spouse can request court orders while a joint petition is pending, a spouse who suddenly needs temporary child support, custody, or a protective order has to revoke first. Circumstances change. Does revoking cost anything? Revoking itself is a mechanism, not a purchase. You're not paying for a new case. Whether a fee applies to filing the amended FL-100 or FL-120 depends on your county superior court, so ask your local clerk before you file. If you already paid the $870 joint petition filing fee or received a fee waiver on it, that payment or waiver was for opening the case and does not need to be repeated to revoke. If cost is a concern either way, a fee waiver is available on Form FW001 for whatever fees do apply going forward. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your FL-720 for you. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.